Good evening, this is John Milburn for LAWS12062 Alternative Dispute Resolution. We're into week 2 of Term 2 2019. Thank you all for joining us for the live session. Again, if you're not able to join us for the live sessions, please ensure that you keep up with viewing these sessions on a weekly basis. Ask questions through Q&A, and if you need to, send me emails. If you do send an email, don't be surprised if I invite you to repeat the email question in the open forum. And part of that is that everyone has an opportunity to exchange ideas, consider what I have to say, and indeed provide their own response as a response to your question. So I'm very keen on collaboration, and I'm very keen for you as students to talk to each other, build some rapport with each other, and to practice some of your ADR skills. This unit is effectively divided into 2 parts, and those 2 parts match pretty closely the assessment regime. By that I mean, for the first assessment, the requirement that I have of you is to undertake a mediation or conciliation. It's a practical application of your ADR skills. And the second part, albeit still a practical application, is of a different type. It's where I invite you to consider, amongst other things, mediation and conciliation, but a whole range of ADR processes in coming to decide an appropriate course of action in providing advice to a client. So I do believe that I've put up on the Moodle site examples of past take-home papers. I mentioned that last week, I believe. And if you're able to look at those and give some thought to how you would go about answering those, it will give you a good idea as to what you need to do to consider in preparation for the take-home paper. So let's start firstly with some practicalities in terms of the first assessment piece. At the moment, you would note on the landing page of Moodle that I have a list of groups that are working together. And from the Q&A section, I was able to ascertain what I think are some groups, but I've recorded them in draft. So you'll see that the groups are confirmed or draft. If any of the detail that I put on the Moodle landing page, and I take it you all know what I mean by the landing page, the opening page, if you like, under latest information. If any of that information is incorrect, then please let me know. Do send me an email. If you're referring to others, please CC them in on the email to me so that I can reply all and acknowledge what's there. So is there any way to look at group sessions of 2 cannot reach one of our group members? Yes, look, if you can't communicate with a group member, one of the reasons for that might be that the person has, regrettably, withdrawn from the subject. And occasionally people do that and don't tell me or others. So if you're having concerns, you're not able to contact a group member, feel free to contact me. Again, do it by email, CC the other members of your group, including the one where you say you're not able to contact. I might be able to do some background research, and if you simply have no confirmation or communication from that person, as much as it pains me to do it, I will remove them from the group and will reallocate that person. If as a result of being removed from one group to another, you can blame me because I'll make the decision based on the information I receive, and if there's a lack of communication, we'll see if we can work on remedying that. Now, the groups are really just for convenience. In other words, there's no particular magic in having a group with fellow students. You can join with any students in the class because it's an individual assessment but done in a group context. And if you're really struggling, you can ask to join a group of 3 as a 4th member, but seek their consent first. And if you do obtain that consent and everyone's happy, send me an email, make sure you CC the other 3, and I'll update the records. So there's no problem in having a group of 4 if you wish. I only mentioned 3 because then you've got a convenient, one's a mediator and the 2 others are participants rather than somebody sitting out. But you can have a group of 4. In fact, if you're really keen, you can offer your services as a participant for another group. So if you're in one group of 3 and you want to join a second group, I have no problem at all with that. You can only have one assessment piece, of course, but if you want to be a participant to help some other fellow students by assisting as a participant in their group, feel free to do that. If you only have 2 people, then you can ask me to fill the void. If you look on the landing page and you see there's a vacancy, feel free just to send me an email, CC the other 2 in if you can, and say, I'd like to have that spot, please, and I'll pop you in that spot. So where it says vacancy, it's basically available to anyone. All right, any questions about the grouping or the way in which I'm trying to communicate with everyone about the groups? All good? All right. And you have plenty of time before the first assessment is due, but please don't leave it too late. Experience will tell me that sometimes people are a little more relaxed than they should be, and for some people there will be a late flurry, which is unfortunate because this exercise is one that should develop over time. It's not something that you write on the last night and perform. It's something that you need to think about and develop and apply some of the skills that we'll be talking about, particularly over the next 2 or 3 weeks. All right. In terms of mediation, your role is to assist the parties in understanding the position of the other side and to identify real issues and discuss those issues, hopefully with a view to coming to a final resolution. That's kind of the idea of a mediator. Can anyone tell me the difference just between mediation and conciliation? I'll give you a hint. I'm looking for the extra things that conciliators are allowed to do and should do over and above that which a mediator does. Any thoughts?
The conciliator will provide advice.
Will provide advice?
Yes.
Yes, correct. Thank you, Gemma. That's one. And the second is a little more specialised, and that is in the context of court or tribunal appointed mediators or those that are appointed from an outside agency. They are entitled to either make decisions, which could be final orders or directions, or they may provide reporting. So thank you, Peter. Thank you, Mary, and also some good comments there from Gary. And thank you, Gemma, for that response. So if you choose to be a conciliator in your assessment piece, then you can expect to be called upon to provide a little more in terms of the content than would be the case with a mediator. Now, from your reading, I'm sure that you've identified that there are many different styles of mediators, many different styles of mediation, from that which is very much where the mediator takes a passive, for want of a better term, role, right up to the point where the mediator can be quite directive. And different organisations have different preferences in terms of the type of mediation that is undertaken. So it is useful in the context of intake to provide some indication to the participants as to the style of mediation or conciliation that you intend to conduct during the session itself. So if I'm going through a standard intake, which I usually allow half an hour per party, I will explain the process to some degree, but also explain my intended style so that the participant has an idea of what to expect. They're not walking in cold and being, to some degree, shocked or surprised by the content. Gary asks a very good question. even if passive, as I've used that term, should the mediator always be in control of the process? And the answer, very good question, the answer is a resounding yes. Even in a non-interventionalist type mediation model, even where the mediator is more adopting a role of facilitator rather than quasi-conciliator, the mediator is always in control of the process. But when I'm in passive, and I'm really trying to think of a mindset rather than necessarily being literal about the use of the word passive, I'm really talking about those techniques that can be used on occasion, which may not be used in a more facilitative approach, such as brainstorming or reality testing. And we'll talk more about those in the next few sessions. Can I ask you this? Has anyone started yet to think about their opening commentary, their opening statement for their assessment mediation or their assessment conciliation? Well, I've got one yes. If not, we need to start on that this week. So as you're thinking about your assessment, you're thinking about the content and the tone of your opening statement. From an assessment perspective, this is very important. So let's think about some of the things that need to be discussed. We talked about this last week, and I can give you some idea of what I do. So at the start of a mediation, and Gary says, I intend not to send ground rules, but endorse mutual respect. Okay, that's a good philosophical approach. It would be unusual not to set some degree of ground rules, but you don't have to call them ground rules, is one way of doing it. So to endorse mutual respect, I think that's good. Okay, so you can be creative about this. So if I'm undertaking a mediation or conciliation, the first thing that I would do is to introduce myself. That's probably going to be a perfunctory exercise, given that I'm likely to have had an intake with them. And the intake is sometimes face-to-face, or it's sometimes by telephone. My personal preference is to undertake an intake session like this over audio-visual. So the first thing is I would introduce myself, give some confirmation as to why I'm there, the basis upon which I've been appointed. Usually the mediator will confirm that the mediation agreement has been signed, but everyone probably knows that before we get to the session. And if there are outside third parties attending the mediation, that is, people that are not direct participants in the dispute, they might be advisors or managers or something, then they need to sign a confidentiality agreement. And sometimes you need to obtain the consent of the other party before third parties can attend the mediation. So identifying who you are, what you're doing, as in a mediation or conciliation, how you've been appointed, and who the other people in the room are and that they've signed appropriate documentation is probably the next thing that I would cover. I would thank them for attending, and that's often overlooked. This is a voluntary process. So by thanking them for attending, you are reinforcing the voluntary nature of the ADR proceeding. You can say outright, this is a voluntary process, feng shui. But I am a little bit reticent to emphasize that too much, because that carries with it the entitlement of the parties, as it were, to get up and leave. And as a mediator or conciliator, you don't like walkouts. If any of you are particularly brave during the course of your assessment piece, you could direct or encourage your participants to threaten to walk out if you really want to showcase your skills, I'd be fascinated to see how you go about drawing them back into the mediation process before they leave. And it is quite a skill to do. What I do, and I'm digressing here, I know, but what I do if I've got a threatened walkout is firstly, lower the tone of my voice and slow the speech so that if they're at all interested in what I have to say, they have to come to me a little bit in order to hear me. The last thing that you probably want to do is raise the volume of your voice and become combatant in that situation. So you've got to try and draw them back in. And then potentially call private meetings, but I try not to do that, at least at first instance. Bring them back in and give them something to think about in terms of the benefits of staying and the benefits of having this matter resolved rather than walking out and making no progress. Anyway, you get the idea. So coming back to the opening statements, the sort of things that I like to cover, like to see an ADR practitioner deal with in that opening statement. I guess part of explaining why you're there is to explain your role, that you are a mediator, you are a conciliator. Can I ask you this? If you say to someone that you are there as a mediator, do you think it may be appropriate to say, I'm a mediator, and you understand that means I am not something else? And if so, what is that I'm not something else? It's a very cryptic question I'm asking you. You're there as a mediator. You're not there as a judge. Thank you, Peter. And Peter, by the way, you've seen that you're allocated to a group, I think, tentatively. Right, good, very good. You're not there as a judge. You're not there as a jury. Because by saying that, and I actually do say that, what you're doing is, again, emphasizing the subtext that goes with that is, this is your dispute. I'm not here to decide it for you, but I'm providing you with an opportunity, a forum, to take ownership of the dispute and come to a resolution of this dispute yourselves. And allowing them, as I mentioned last week, ownership of their dispute is a valuable resource, something worth keeping. And emphasize that. You'll probably actually be more specific than that, and that will occur probably in reality testing. So Lindsay suggests, I'm not a lawyer, I'm here to assist, to help, and almost like counselling. Yeah, there's a lot to be said for that. So thank you, Lindsay, for that contribution. Another thing that you might want to consider in the context of the opening statement is that you've had no previous contact with any of the parties other than through intake. So just explain what contact you may have had with them, that you've spoken with them by telephone or you met face-to-face. But you need to identify whether you've had previous contact with them or had no previous contact with them. But if you have had previous contact, then perhaps give some indication as to why. So as part of some of the ADR work that I do is institutional in nature, and in those circumstances, there tends to be a dynamic where the institution involved has, if you like, an appointed person to appear at ADR sessions, as opposed to the other side, which is non-institutional, for example, where there'll be a one-off. So it's important that you at least explain to the person who's there as a one-off situation that you have had contact with the other party, given that other party's role within the organisation with whom they have a dispute. Does that make sense? So that at least you're not in a position where you're suggesting there's been bias. So Gary says, I don't agree, John. I think it's important that the parties have confidence knowing that you are a law-trained person. Okay, I think that's, yes, all right. So let's just explore that. Lindsay had said, I'm not a lawyer, I'm here to assist, to help, like a counselling impartiality. Gary says, no, you should say. What I can tell you is that I say that I am a lawyer, and I make that disclosure. Now, if you're not a lawyer, you wouldn't say that, but for the sake of the exercise, for the sake of the assessment, if you want to be a lawyer, you are a lawyer because it's a mock exercise. So you can say that you're a lawyer in that context. And you can certainly say that you're trained, so I agree with you there, Gary. But I think it's important that you say, even though I am a lawyer, I'm not here to give legal advice. Even though I am a lawyer, I'm not here to act as a judge. So thank you. All right, so some good discussion there in terms of how to present yourself. Mary says, for a specialist conciliation, yes, but not for mediation in terms of advising that you're a lawyer. And Lindsay says, yes, Gary, but don't represent yourself as a lawyer. It can be intimidating to both sides. So there is a degree of personal preference there. I do say that I'm a lawyer when I think of it, or it becomes apparent, or it may be that I'm there in some other role as a member or something. But explain why you're there and what your role is within that context. You need to explain something about the process. Now, you may have done this in intake, but for the sake of the mock assessment, then you do need to explain what this is all about. Now, very often a mediation may be allocated for a period of, say, 3 hours. Would be a reasonably standard period of time for a straightforward mediation dispute. Can anyone remind me how long I've given you for your exercise? It's not very long, certainly not 3 hours. Is it 20?
I think you said 25 minutes.
25 minutes, Gemma, thank you. 25 minutes, says Mary as well. So you've got 25 minutes, don't go beyond 25 minutes, and don't feel as though you have to use every ounce of the 25 minutes, but do explain to the parties that you have 25 minutes for the mediation session, and you might explain that often mediations run for a longer period, but you've been authorised to run an expedited mediation session or something along those lines. So just give them some idea of what they're facing and give them some idea of the process. Now, it's probably good form to ask if people have time constraints, because if you're mediating a dispute and you haven't been through intake and you're not sure what intake at all they've received, then they may have an expectation that the mediation is a chat and that it takes 15 minutes. So from the start, explaining the process, the time constraints, and the likely process is important. And get some feedback. Do you have any time constraints? Another important thing is this, that you need to clarify with the parties involved that they have the authority to make decisions. Now, that might be obvious. Given that I've said that it's important to encourage parties to retain ownership of their dispute, one would assume from that that this is their dispute and therefore they have authority to resolve the matter. But that's not always the case. It may be that the person in front of you is one of a couple or a representative of an organisation. And you've got to ensure that that person has authority to make decisions. What you don't want to do is find yourself in the embarrassing situation of resolving a matter, and come the agreement, the person in front of you says, yes, that all looks good, but I'm not authorised. I'm going to have to take this back to my boss. My boss is away for a week. I won't have an answer for you for 2 weeks. The other party had worked on the basis that we're getting this resolved, and I've been saying, something like, let's get this resolved today. So you want to set the ground rules, and part of that is knowing the level of authority that the party before you has. And there's a little nice discussion going on in the background in terms of lawyers. Some people not trusting of lawyers. it would seem. And issues around trust is important. And surveys and research says, Mary, people don't trust lawyers, especially in many common mediation matters. But sad, but statistically true. So I'll leave that for your judgment as to how you wish to categorise yourself in the mediation or conciliation process. As I've mentioned, I do say I'm a lawyer, and so far I haven't had too much pushback from that. But I understand that different people have different expectations. Now, a good thing to clear up at the start is the issue of designation. And sometimes people prefer first names. Other times people prefer a more formal approach. What's a good way, do you think, to resolve the issue of how we address each other in a mediation session? Yes, Mary?
Introduce yourself and
yes.
ask them.
Yes,
ask
that's the answer I was looking for. Ask them. You may find occasionally someone says first names and the other one says no, we want more formal approach. You're just going to have to resolve that on the run. But I think ask them. I tend to start with the Ms. Brown. Would you prefer I called you Ms. Brown or Emma? Whatever it might be. Almost you, Gemma, but I went with Emma Brown. So see what the parties want to do themselves. And if they choose first names, I'll usually encourage them to use first names with me as well. Generally, I think first names is a better way to approach it because you are looking for some honest exchange of ideas and communication. And I think using first names generally is a good way to go. A little trap for young players is please don't forget their names. Once you've invited them to call, if they've said, well, yes, my name is Emma, but please call me Mary, make sure you write that down straight away so that you get the names correct. All right, you've already told them you're not there as a judge or jury. You've told them that you're not presenting a decision. It may be a little different if it's a conciliation because you may be making some orders or at least indicate to them that it is possible. And what you're trying to do generally is encourage them to take ownership of the dispute. During during the opening session or soon after, I may make a comment to this effect that in my experience, it's only natural for people to want to tell me things or ask me questions. But soon in the process, very soon in the process, I'll be inviting you to engage with each other in that way. So whilst I expect that there will be some communication directly to me, just let them know that I expect that they will be talking primarily to each other. And it does happen. In practice, people want to tell you things, and then you've got, when you're undertaking the work, you can showcase your skills by showing me how you encourage the parties to communicate with each other. Sometimes I use a little combination of silence and body language to do that. I don't actually say necessarily, no, don't talk to me, talk to her. And sometimes I do that. If I've made it kind of clear that they should be talking to each other, I might just pause for a moment and just direct my hand across and look across, and they get the hint. Do you see what I mean? So it's sort of that gently guiding the parties to do what you want them to do. It's all part of taking ownership of their dispute. So I've mentioned that we should explain the process. In a nutshell, can someone tell me what is the process in a mediation? I've suggested that 3 hours is a usual sort of time for a simple mediation. What do we do within that 3 hours? Is there kind of a structure to it? What's the first thing? The first thing that we do,
Identifying issues.
yes, but not necessarily what I've got in mind is the first thing that will happen in a mediation.
Introduction, and then
Yes.
you go through what process will take place that day, particularly if you haven't done any pre-planning communication with the parties, so they
Yes.
know exactly what the rules are and what is going to happen and take place, and what possible outcome and at how it's going to proceed.
Yes. Thank you, Mary. So perhaps I can put it this way. What I'm looking for is, and we're getting some really good chat comments. Paris says, get to know the people. That's a good point. Gary says, make them comfortable in the process. Is very good. And Emma says, find out what are their expectations. I think that the first thing to do in a mediation is the process of making the people feel comfortable. And the first formal part of the process is the mediator's opening statement, which is really what I'm talking about tonight, that opening statement from the mediator. Once we deal with the opening statement, and in your case, you've got 25 minutes, you really wouldn't want your opening statement to go for more than 5, probably 3 to 5 minutes. After the opening statements, I would generally hear from the parties who provide their opening statements. So I give the opening statement from the mediator as the mediator or conciliator. I then ask one of the parties to give their opening statement. Again, you don't want it to go for too long. And given you've only got 25 minutes, you should really have a pretty simple factual scenario, with maybe 2 or 3 issues only. So nothing too complex factually, otherwise you won't have time to deal with the matter. And I generally start with the applicant. So if I'm dealing with a civil dispute, I'll start with the plaintiff, or if you like, the party that brought the matter to ADR. I would normally go with them first. They give it's their opportunity to say, here's why I'm here, here's what's important to me, here are the important facts, and here's what I'd like to see happen. That's what the opening statement of the party is all about. The other side provide their opening statement, which generally is a response to that which was said by the first party, but need not be. And I do invite both parties to be patient and listen carefully while the other is talking, no interruptions. So during the opening statement that I make, I will explain this. Once the parties have provided their opening statements, then I'll work with them to create an agenda. And that's likely to be a couple of words or a couple of phrases or combination of things. So something that just encapsulates the nature of the dispute. And it may be that your agenda of, say, 3 items is drawn 2 from what the first party said and 1 from what the second party said. Very often there's a commonality and that both are talking about the same things. But it's up to you as the mediator, the conciliator, to create the agenda, or if you like, the list of issues, based on what the parties have said. And I like to do that in conjunction with them and have their agreement. And Gary's given you a plug, Catherine, saying you posted a great piece on discussion page today. We'll look out for that, and I commend that to everyone. So thank you. So we'll have the agenda prepared, agreed upon, and then the next step in the process is we'll have a joint session, a common session. So if you've got one party against another party, and the mediator, there's 3 of you in the process, the joint session is where all 3 of you are engaging with each other. Naturally, they'll direct things towards you as the mediator at the start. You encourage them to talk to each other. That's the next stage in the mediation. Usually after that, we'll have private sessions. And the private sessions are where you as the mediator or conciliator will engage privately with the individuals in turn, in private, one after the other. Do try to give them equal time and let them know that as far as possible, your intention is to give them equal time during those private sessions. What you don't want to do is give the impression of bias throughout the process. And one of the ground rules for those private sessions, or one of the ground rules for the private sessions, is confidentiality within the context of confidentiality. So the whole process is confidential. We'll explain what that means a little more. But within the private sessions, I make it very clear to the parties that anything that they tell me or I tell them, any discussions we have, in other words, remains private between the two of us, and that I won't disclose anything that we discussed with the other side. And I mentioned that at the start of the private sessions, as well as in the opening statement. The idea of that is that you can then provide, you can build some further rapport with that individual, see how they're coping, and you can, if it's a conciliation, you can provide them with some feedback and maybe some advice as well. So that's the next stage in the process. And then after that, we have the second joint session, which is specifically designed to encourage the parties to make offers to each other so that we can hopefully resolve the matter. After the second joint session, we go into the settlement or the agreement phase where we write the agreement, and then we have the conclusion. So that's the standard process, if you like. For the assessment, are we expected to carry out the private sessions? That's a very good question. Thank you, Emma. The answer is no, you don't have to, but you may if you wish. I would certainly expect you to mention the possibility of private sessions in your opening statement. I'd be disappointed if you didn't mention that as something that may happen. Whether you actually do it or not is a matter for you. It may be that it's just forcing something that doesn't exist to have private sessions. But it's probably not a bad thing to do in your assessment piece, but you don't have to, and you won't be marked down because you choose not to. So the question is, so how is the settlement binding is another question. It can be binding. In some mediation models, an agreement is not binding, and that depends on the level of formalization of the mediation in question and the ground rules upon which it's made. So, for example, some mediations conducted under neighbourhood dispute mediation rules are not legally binding, but many times they are. And one thing you can do in your opening statement is advise parties that if they need to have a break for any reason, including speaking with a lawyer to obtain legal advice, then they should ask for that break and take that opportunity. Because in the opening statement, you'd make it clear that you are there to encourage the parties to come to an agreement, and if they do come to an agreement in this model, the agreement is intended to be legally binding, but it doesn't have to be. In your model, it might be that the agreement is not legally binding. So that's, again, part of the intake and the rules. Yes, Michael?
Anything of real value, you're going to want to sign a deed, just because, like every normal court mediation, people are going to agree there, then go home and go, oh crap, why the hell did I agree to that? And then, so you really want them to be squared away.
I agree. And certainly in work that I undertake, I make it clear that I expect that if there is an agreement, it's legally binding. All right. And lodge with the court, says Leonie. Yes, so that's an opportunity as well. So coming back now to the opening statement, I expect that you would at least explain the process briefly to the participants so they've got an idea of what to expect. Not just, it's not, you know, they can see that you've got some pathway that you're going to lead them through. And when it comes to the process, as we discussed earlier, you are in charge of that, and you control the process, even though they retain ownership of their own dispute. Another important thing to mention to the participants in the opening statement, during your opening statement, is that the process is confidential. And I do temper that by saying that the intention of confidentiality or without prejudice discussions is that what is said in the room effectively stays in the room, but there are some clear exceptions to that. The most obvious exception is that anything which is part of the common dispute, part of the material leading up to the mediation, can be raised in court. So if we're discussing a dispute about a contract, then merely because we discuss the contract in the mediation does not mean of itself that discussion of the contract is off the table, so to speak, in court proceedings. That wouldn't make any sense. But when we talk about confidentiality of the process and what is said during the process, what I'm really trying to impress on the participants is this, that if they say something by way of compromise, or they seek to settle the matter by extending an offer, then that is confidential. And you can picture a situation where someone's in a witness box giving evidence, asked a question, and then responds by saying, yes, but in mediation, you offered to do this or to do that. That cannot be said. Does that make sense? Because what you're trying to do in that confidential process is encourage the parties to speak freely, not to be guarded, and to know that if they do make a concession or extend an offer, then that can't be used against them in later proceedings. So if we have to, go back, put on the litigation face, and what was said in trying to settle the matter won't be used against them. All right, so you're there to encourage discussions, and because it's without prejudice, you can encourage the parties to extend offers, to make concessions. What else can you do? What else should you say to the parties during the opening statement about encouraging discussions within this confidential matter? I know this is a bit vague. So you're saying to the parties, this is confidential. It means you can extend offers, you can make concessions. What else might you be encouraging the parties to think about within that context? That's too cryptic. I'll let you know what I'm thinking. It comes back to this. If the parties involve themselves in litigation, they are divesting themselves of ownership of the dispute, right? They're asking an independent arbiter of fact to make a decision by applying the law to the facts. So what a court does. They're saying, we can't sort it out, you sort it out. You give us the answer. In a mediation or conciliation, it's confidential. You're encouraging them to take ownership of their own dispute. So that means that you can encourage them to come up with novel solutions, solutions that a court could not make. If you've got a contract dispute, the court will make a decision about equitable remedies or legal remedies, but that's it. The discretion in the court might be reasonably broad, but it's not novel. The court can't say something like, what's that old joke about the jury that comes back with a decision of not guilty to cattle rustling, but he's still got to give the steers back, you know, that type of thing. So you can come up with novel ideas, novel solutions. So that's what I really mean in terms of confidentiality, that you can encourage concessions and make offers, but you can also be much broad in your approach and think of, to use an Americanism, left field approaches to determining the problem. Of course, what you're trying to do in this process is encourage the parties to come to their own resolution. Can anyone tell me now, just briefly, and this is my chance to have a sip of tea, can anyone tell me why it is important that they might come up with their own solution rather than having a solution imposed upon them by going on to litigation? Yes, Peter.
If they come up with their own solution, they own the solution, and therefore they're more likely to be carried through.
Yes, very good. And Michael came up with the same response on the chat facility as you were speaking. So that's very good. They're more likely to follow through with that if they've come up with the decision themselves. Yes, Mary. Did you want to say something there, Mary?
I was just going to say that it gives them ownership.
Yes.
They've happily agreed, and so the parties then end up content, and you know, the dispute is actually resolved.
Yes, I think that's a very good point. One thing that I often say to parties is during the opening statement, look, I encourage you to come up with your own resolution of this dispute. It may not be what you have in mind, it may not be what you want, and indeed, you may come to the resolution and be a little disappointed with the outcome that you've agreed to. But if both parties are a little disappointed, then maybe it's just about right. What are some of the other advantages of the parties coming to their own resolution at the mediation?
The other thing is that
Yes,
if they come to a solution and don't have to go to court, once they go to court, there's a winner and a loser. However, if they come up with their own solution, it's a win-win situation.
That's a very good point.
Situation on both sides.
Yes, that's a very good point. And you might use that as a mechanism, a tool in your toolkit in order to encourage the parties to come to a resolution. How would they feel if they are told by an independent person that they have lost the case and that the other party's case is preferred to them? Gary says one way to approach this might be to encourage the parties to resolve, even though they're not totally happy. Partial is better than a total loss. Mary says, and this is a very good point, come to your own resolution and you will save money and you will save time. What about the emotional and other costs associated with proceedings? Perhaps you could remind the parties of that it's all very well to go to court, but at what cost? Mary says the cost of money, the cost of time. The other thing is the emotional cost. What about reminding parties of the things that they might have done with that time and that money instead of litigating? So that if they take a loss now, to some degree, that may be ultimately a much better result, even if they were to do better in court. By the time they've lost money, time, emotional, Mary says they could lose everything. Michael says it can take 2 years and put your life on hold. So these are all really good points. What I'm going to suggest to you is that you need to at least cover some of these, or at least consider covering some of these things in your opening statement. What you might want to do is leave them in reserve so that if you're finding that we're getting bogged down, you can resort to some of these things. But have the information accessible, if you like, as part of your toolkit, so you can draw upon this tool, this technique, this statement or this phrase in order to get them back on track. Or you might use these things in private sessions by way of reality testing. So Gary says, at mediation, can the parties be represented? They certainly can be. Different organisations may have different rules about it. My personal preference is I always like the parties to be legally represented. Some mediators, conciliators don't like that. They find that lawyers get in the way. My preference is always for the lawyers to be there. All right, and Gemma says, yep, litigation can take many years. Michael says 1 step back, 2 steps forward, and Gemma agrees. So using a statement to the effect that you may come to an agreement, you might be a little disappointed, but if you're both a little disappointed, then maybe it's about right. Might be sort of a useful little stock phrase or concept. Make sure that you remind them of the confidential nature of the process, but there are some exceptions. One is if threats are made, then as a mediator, you can break rank, as it were, and disclose those threats. And finally, in an intake opening statement, I'll just ask if there are any questions. Before we begin, do you have any questions? Is a useful way of finishing an opening statement. So during the course of nearly an hour now, I've raised things that you might consider putting into your opening statement. I haven't raised everything you could, and you may say, not happy about some of those things that John mentioned. I think there are other things that are important, more important. I'm going to put those in. So don't for a moment think that just because I say this is what I do, that makes it right or the correct answer. It's far from it. And those of you that have worked with me in the past, you will know that I have said things like, if you're preparing an answer in trusts or equity or whatever it might be, you may come to a completely different answer to me and still get top marks because I'm more interested in the process and your logic. Same applies in ADR. That said, there are a few basics. If, for example, you don't say anything about confidentiality in an opening statement, I will probably not be very happy about that. So I'm giving you some license, but not too much. I hope that makes sense and it's not too contradictory. It's important that there's a flow in what you do. From a practical perspective, during the course of your opening statement, can anyone tell me about your body language? The body language that you, as a good mediator, conciliator, would like to see.
It
Yes,
should
Emma?
be open and,
Open, yes.
and conducive to people speaking to you. There was a word, but I can't think of it at the moment.
Empathy, yeah. So Mary says be passive and friendly, yes. Tyler says non-threatening, relaxed, yes. Gemma says make eye contact and confident. Yes, these are all good things, and what Peter said as well. Gary says eye contact, be approachable. Gemma says watch space and distance. That's interesting. What do you mean by that, Gemma?
So, I mean, don't be imposing. Some people don't like it when people are too close to them.
Yes.
So by watch your space and distance, I mean, if you're going to stand or if you're going to sit, don't be too close.
Mm-hmm.
Don't be too close, don't be too far.
Yes, that's a really good point. So these are all important things for you to think about. So during the week, I would expect that you would have completed your draft opening statement. If you wish, you can write it out in full, word for word. I think you would need to be extremely talented in order for that to be workable for the real thing, for the real mock thing, if you know what I mean. My personal preference is dot points. If you're going to have notes, maybe make them dot points so that you can maintain that eye contact that you can build that rapport. It's probably impossible to do that if you're simply reading the material. I hope that makes sense. But by the end of the week, I would hope that you've mapped out your opening statement, and it'll only be a draft. You can modify that as you go on. And maybe do some practice runs so that you've got an idea of what you will say within this, say, 5-minute period that I've mentioned, just as a guide for the opening statement that you make. All right, Gary says, from a practical perspective, make sure that level seating. Yep, so that makes sense as well. Okay, any questions about what we've covered tonight? This concept of the opening statement of a mediator or conciliator. All good? All right. You've all been very patient. Thank you very much. And I'll end the recording now. We'll see you next week, and have fun with this subject, okay? All the best. See you then.